Okay, well, I'll make this brief so that we can get into the discussion. We've gotten some really vivid sort of illustrations of what I would identify as a kind of emerging consensus in Latin America about the imperative of openness and the right to know. The consensus, I would say, almost as an unintended consequence, comes in part out of the truth commissions. The flawed truth commissions, the truth commissions hobbled by terrible mandates, the truth commissions that were not allowed to name names, the truth commissions that were stopped from leading to prosecutions or any kind of judicial implication. And yet the truth commission process, beginning in the 1980s and sort of really peaking in the 1990s and early 2000s, produced a demand for information that the human rights organizations really hadn't figured out yet. Not broad information about a case or information related specifically to investigation, as the right to truth is sort of defined within the Inter-American system, but rather documents, records. I mean, these truth commissions are doing historical analysis of the causes of conflict. So, for example, in Guatemala, the Guatemalan truth commissioners went to the armed forces and the police forces with a copy of their mandate that said, this commission has the right and the responsibility to request from the parties of the conflict the records of their participation as a part of its historical investigation. And in fact, some of the armed insurgency groups turned over collections of records. Incredibly, the military and police stubbornly stonewalled that commission for the entire year and a half of its operations. And unlike many of the truth commissions that existed in Latin America, the commissioners in Guatemala went public with it and actually held press conferences complaining about the military's refusal to turn over records. And if you look at their huge, sprawling 12-volume report that the Guatemalan Truth Commission turned out at the end of that year and a half of work, one entire volume, volume 12, is devoted to documenting through the letters from the commissioners to the military and the military back to the commissioners of the efforts of the commission to get a hold of these documents, which they felt was their legal right. That's really important, because actually that suddenly produced a kind of a record of the refusal to open the archives. And it's been used ever more and cited ever more as an example of the resistance on the part of governments to collaborate with human rights and justice efforts to that extent. The rising demand for transparency and archives is also linked to this sort of gradual shift that we've seen in the region over the last 10 or 15 years from the truth commission phase or the truth-telling phase into prosecutions. And you know, you all know this is happening all over the region in very surprising and unexpected ways. And suddenly there are lawyers, private lawyers for the victims or the families, there are government prosecutors, there are magistrates, and depending on the country and the political context and the political will of even an individual involved in the case, they're starting, again, to go public with their demand for records on the part of the government as evidence in these cases. And it's becoming harder, I think, for governments to claim that these records don't exist or that they aren't able to turn them over. I mean, the evolving jurisprudence in the Inter-American system is making that, I think, ever more difficult for the governments to claim. And finally, I mean, as a part of, well, not finally, third of all, because I think there are four pieces of this kind of identifying what is this emerging consensus on openness and the right to information. The appearance of these archives in a handful of countries in Latin America has woken up this sort of keen interest within those countries and all over the region on what are the documents that actually still exist. And as Jo Marie says, we know perfectly well that in the majority of these cases, of these institutions, they do not burn or destroy all their records. Number one, it's impossible to destroy the paper trail of an authoritarian regime that lasted for 20, 30, or 40 years. It's simply impossible. And number two, we found, through experience, that these bureaucracies of power don't want to let go of their paper, even after their counterinsurgency project may be delegitimized or there's a historical judgment on it that casts a very different light on it. Those bureaucracies both live off of their documentation and continue to take a certain pride in it and don't want to give it up. So I think the opening of archives in places like Paraguay and the Archive of Terror, so-called, obviously the Guatemalan police archives, the Mexican archives, which in a very unusual move was transferred to the National Archives by a sitting president as a part of a kind of opening up the archives of the past effort that he made in the political transition from the authoritarian regime in 2000, and that I think has also pushed this dynamic. And finally, and this is the Foia Laws. These 7 countries that have passed these laws with these sort of special prohibitive articles that specifically disallow the withholding for any reasons of information relating to gross human rights violations or crimes against humanity is a very interesting and, as Michael pointed out, almost totally untested development on the legal front. And it's something that I think we're going to be watching over the next 5 or 10 years, is how individuals, families, how human rights organizations, and how the sort of pro-openness, pro-transparency institutions avail themselves of that new and very interesting instrument. I think part also of this new interest in the, or this new demand for openness that connects to human rights and justice struggles has to do with the fact that these are citizens now living in countries that all are, as far as I know, members in good standing of the inter-American system and declare themselves to be defenders of the human rights of their citizens. And yet these same countries are able to sit on, in silence, thousands and thousands of archives that may contain criminal evidence of their own institutions and individuals within those institutions committing gross human rights violations. And that's, I think, a dawning awareness at some level. The problem is that though we have this kind of evolving jurisprudence, we have some new legal instruments in the Foia Laws and some new archive laws, we certainly have these newly opened, very few, but newly opened, very important human rights archives of the military and police. I think most of the community of human rights defenders and the people they're defending are very ill-equipped to kind of know what to do with this. Great, we have a new FOIA law that has this special clause. Well, I mean, how do you file a FOIA request? How do you ask for documents from your government using this new instrument? Nobody's quite clear on that, depending on the country. The Mexicans actually put into place an information institute that, as part of their mandate, has to go around the country training people, has to invest resources in NGOs and civil society organizations to help them learn how to use the law. Peru doesn't have anything like that, and the Peruvian FOIA law is hardly used. So there's all kinds of problems and, I would say, opportunities around there. Of course, the governments continue to put up sort of a fierce resistance on turning over these documents, and part of the problem, I think, for us, or the dilemma for us, or something that we can solve together, is we, as a human rights community, I don't think have found ways of insisting, either legally or politically, sort of lobbying on the issue of the obligation of these states to open these records. This is not a favor we're asking. These states have to open these records. And I would like to see us using the jurisprudence coming out of the inter-American system, some of the actual legal developments in these countries, and the cases that have actually been able to avail themselves of these documents. I would like to see us using this more effectively in these countries. The Lima meeting to which the flyer to this event made brief passing reference was a gathering in September that the National Security Archive convened, although, you know, essentially in partnership with 30 other organizations and individuals, of prosecutors and judges and human rights activists and people like Joe Marie and people from Brazil and people from Argentina, people from 10 different countries around Latin America, archivists and openness experts and people working on human rights cases, to sit in a room for a couple of days together and both talk about the problems we've had, but also the successes we've had, to try to swap experiences to see if we can learn anything from each other about how to push this issue some more. The inspiration for the meeting very much came from the Araguaia ruling and really from Sahil's role in the Araguaia ruling and the way that it was articulated in the inter-American court findings, and it was, I mean, I see the ruling as a bit of a turning point. And as you say, the ruling has a bunch of flaws. I would say that the biggest flaw for me, and you didn't articulate it in exactly this way, but maybe you said it in a different way, is that the strongest findings about the obligations of states to produce records are in the sort of guidelines or declarations of the ruling, rather than the reparations section that actually orders the state to act on those. So I think one of our big challenges now is to find, as Michael really said, vis-a-vis the Diario Militar case and other cases, is to find ways to push the court just that, you know, few steps further to incorporate those very powerful and I would say almost radical guidelines that are included in the Araguaia ruling into the reparations section of the next major ruling on the right to information. So what were the conclusions of the Lima meeting? The Lima meeting looked at essentially the issue of prosecutions, archives, human rights needs and the right to truth, and the issue of the Foia Laws and so forth. So we looked at a bunch of different categories that related to the right to know, the right to truth, and human rights struggle, and together we came up with a whole bunch of ideas about where we could go from here to try to push this issue down the road a little bit further. And I'm not going to sort of detail what each conclusion was, but essentially on the most macro level, it had to do with creating a campaign in Latin America for the right to know, and that organizations such as the organizations here in the United States and the organization in the Americas that are connected with human rights and justice struggles need to incorporate or sort of take up this demand as a part of our policy and political work that we do in the region on human rights issues. And I wanted to sort of just name maybe 2 or 3 or 4 ideas about how that might work in Washington, you know, from the perspective of WOLA or from Human Rights Watch or some of the organizations here, because I think we can play a role in helping push this issue. I mean, one just very simple thing is promoting dialogue and, you know, producing some analysis on this issue of national security and human rights as it affects access to information. Because a lot of our organizations have talked about kind of national security and how it produces the internal enemy, and that can produce internal conflicts that target unarmed civilians. We really haven't talked yet, I don't think, as a community about how national security impinges on our right to know when you talk about human rights violations. That's one. 2, I do think that one of the key parts of the Araguaia ruling, recognizing that the lack of access to information for families, victims who survived, and I would say societies at large, is a form of torture. That is a very strong position. And I think the human rights organizations can take this up and think about ways to use that effectively as a human rights issue. And a third issue would be to think about how to generate a Washington campaign for the right to know on human rights violations. Now, some of you, very, very few of you actually, looking at this young room, might remember that now, 12, 13 years ago, a group of organizations, including WOLA, LOG, National Security Archive, and a bunch of others, actually tried to get a law passed called the Human Rights Information Act, which was specifically about requiring the U.S. Congress, requiring federal agencies to declassify and open records that had direct evidence of human rights violations. It did not pass, but we did put up a good fight. I do think now, yeah, right. I do think now we have a little bit of an opening, and it's something that I'd love to talk with people about or conspire on down the road, to think about whether or not we could mount a campaign for some kind of fast-track declassification of records for prosecutors. I mean, here we've got people in Peru, people in Guatemala, people in Argentina, Chile, brave enough to take on these trials with all their flaws and their problems of political will and broken justice system, but take on these human rights trials, and yet even when we in the United States may have information directly related to the crimes at stake in these cases, we have no mechanism for providing that quickly. We have a bunch of pretend mechanisms like mutual legal assistance treaties. They do not work. We need some fast-track mechanism to declassify these records. And finally, and I think I'll stop there, as I said, I do think that the international human rights organizations, the big ones, the famous ones, the Amnesties, the WOLAs, the Human Rights Watch, I think we can sort of incorporate into our portfolio of human rights work the demand that states honor their obligation to open archives, support criminal cases with evidence, support families search for documentation or historical memory through the opening of these records. And that's what the Lima meeting was about, and that's what I hope we can continue to talk about today, and on and on. Thank you so much. Great.